Sorry, guys. I think that crashed live stream again. I've got to figure out what is going on and why that happens. I don't know when it stopped streaming. So just to recap, the level of tyranny is what we'll put up with. And if we are willing to put up with them taking monies out of our accounts, taking taxing us, we've already been putting up with the foreclosure fraud and the other things that are happening around the world as the banks literally start to take over as much as they can, global control. We need to fight back. So I'd like to focus on a couple of things that have been happening in the courts, and then how you and I can use this information to, number one, keep our homes. The very first thing everybody needs to do is to keep their home. They need to keep it somehow. And at this point, if you can delay the foreclosure, that's a win. Delay, delay, delay. And the more delay, the more you're able to stay, the more you're able to save instead of paying a fraudulent loan. You don't even know if it's going to pay off your loan, your payments. The better off you'll be positioned when these things start to hit us personally. So I wanted to cover a couple of different rulings. Goldman Sachs mortgage appeal was rejected by the U.S. Supreme Court. And this is a real win. They wanted to ignore investor complaints. But the fact is, they suffered a defeat on Monday because the U.S. Supreme Court let stand a decision that forces Goldman Sachs to defend itself against claims it misled investors about mortgage securities. Well, we all know they did. And the fact is, at least at the Supreme Court, they are now supporting the investors. It's a decision against the banks. That's a fairly significant one because in this particular case, Goldman Sachs is going to have billions of dollars of lawsuits against it, and those are going to be allowed to proceed. Obviously, their stock is already down. We can't hope that this is just the beginning of the end. I think this is just another episode in the battle, but it is a plus for the people. And so we can take heart that at least some courts at some level are saying no to the banks. So here's another response. This is a lawsuit in a particular, it's Culhane versus Aurora Servicing. And in this ruling, the court is allowing the legal challenges to mortgage assignments to hold. You can challenge mortgage assignments. That's a big win. It really is a big win. Now, the court is also saying we are going to uphold MERS. MERS is okay. We're not going to rule against MERS. But for the specific mortgage assignments, yeah, owners can sue on that and can force legality for the assignments on the part of the banks. So that is really a plus for the people. You can read the opinion, you can read the article, but I really wanted to point out that the key to using the mortgage assignments, I've got Max Gardner's 12 what does he call it? Dirty Dozen Rules for Ownership of the Mortgage Note. We're going to talk about that in a minute, but in direct relationship to this court ruling that owners can use the assignments as in their lawsuits. But this is another heartening thing for owners trying to keep their homes, and that is the foreclosure timelines have been extending, even in non-judicial states like California. And they talk specifically about California because we just turned the Homeowner Bill of Rights, SB 900, basically has started to shift California from a non-judicial state to a judicial state, in effect. It doesn't mean that when they file a foreclosure, they have to go to the court. They have to file it in court the way they do in a judicial state. However, It extends the timelines. It increases the liabilities for the servicers if they make mistakes. Owners have more rights. We can go to court and sue on specific violations. And what they're talking about here, I just wanted to show, briefly highlight a couple of the items, because this, we can take encouragement from this. If you're trying to keep your home from foreclosure, take encouragement of this, and then pay attention, because we've been trying to bring to you every method we can possibly figure out and dream up to help you delay and stay. Delay the process, stay in the home. Now, right here it says, of all the loans in foreclosure process in January 2012, so that's a year ago, 42% are still in foreclosure. A year later, only 22% have become bank-owned, the foreclosure process completed, and 11% were liquidated through short sales or deeds in lieu of foreclosure, where the people just give up and sign the deed back. And we strongly encourage people to not give up if at all possible, but sometimes that is what they have to do. And so in states where the foreclosure process was handled by the courts, 58% of the loans in foreclosure are more than 2 years past due. If you read down to the article, in judicial foreclosure states, it'll take more than 5 years. This is a plus to the owners. If you are in a judicial state and you are able to delay your sale that long, you make sure that you save those payments. You start hoarding your cash. You start getting ready for a transition, because like we just saw in Cyprus, we don't know where the future holds. It doesn't look good. So let's all get prepared as best we can. Let's keep the house and try to keep as much money as you can. And let's start using other currencies. I want to, maybe later this week, start talking about some of those options. Did you hear some of those concepts that were expressed in that video? Alex said he supports more fiat credit, which is basically black market exchanges, something that is not government bankster controlled. And of course, he really pointed out how they arrested the banksters in Iceland. So how can we push to get these banksters arrested? Let's try to figure that out. Because if we could arrest them and show them we're not going to take this level of tyranny, that could be a real step in the right direction for at least this country and the people in this country. So let's take a look now at the dirty dozen rules for ownership of the mortgage note. You can read the article yourself. I'm just going to highlight these, because one of the keys is that you understand these are the legal arguments that can be used in a lawsuit, in a court, to save your home. This is all about the mortgage notes. And like the ruling in Massachusetts, it gives the owners the right to pursue the illegality of the mortgage assignments, And we already know that the assignments are fraudulent. So here's how the assignments and the note ownership should be working, because as the notes change ownership, each time it does, it's supposed to have an assignment recorded. Of course they don't. So here's number one. Max explains, and this is just an article he's shared so that you can understand the basics. We're back to basics, but as we review the basics, other ideas come to light. So there needs to be an unbroken chain of transfers and assignments, and there aren't. He talks about how basically it goes from the originator, that would be the initial lender, like Countrywide would be called an originator, and it's supposed to then go to the sponsor, to the depositor, to the trust, the mortgage-backed security trust. And we've talked about that. That's reviewed again briefly in the Analyzing Your Recorded Documents, one of my workshops. And then also in the second follow-up on that about trying to simply go to the SEC to find out where is my pooling and servicing agreement. But it's real simple stuff. And I'd like to bring you some more detailed information about that as we proceed. So then he talks about the endorsement and the transfer of the original note. And I have seen, people have sent me their endorsements. They, remember the qualified written request letter goes out to the bank, servicer, and you're demanding a copy of the note, and we want to see those endorsements. they call it an allonge. And so he's talking about what the endorsements are supposed to look like. And sometimes you'll get some of that, most of the time you won't. Sometimes you'll get conflicting information. You ask twice, you'll get two different answers. That's fascinating. And that's come up in court before, where literally the banks have brought two different examples of the same note that were obviously different. The original notes might be endorsed in blank, but then he talks about, if they are, all these other things that should be done legally. If it's endorsed in blank, it's a bearer instrument, and a bearer instrument is something that only the holder of that note, the person that holds that paper, gets paid. So if you have a bearer bond and someone steals it from you, it's gone, it's theirs. They don't have to prove who they are, they're holding that note. So interestingly enough, we've talked about the fraud created with turning these notes into bearer bonds and literally copying them on a copy machine and selling them to multiple parties. We believe the banks did this, and that is one of the underlying causes of why other banks that bought those are trying to foreclose on the same house. They each have a bearer bond. Oops. And we already know from other anecdotal facts, the attorney in Hawaii who has done this research, he found that these notes were often sold multiple times into multiple different mortgage-backed securities. The highest number I've heard is 23. I think the highest in his article was 6. So if you take the same note and you make copies and you resell them to all of these different mortgage-backed securities, each one of them insured, then every time, of course, that the government pays the insurance, they get paid over and over and over. This is how the banks and their fraudulent activities have just mushroomed onto the backs of the taxpayers. Now he talks about the pooling and servicing agreement. It includes the origination and the cutoff dates for the mortgage notes, and we've talked specifically about that, which makes every assignment after that illegal, because these are very strict. Each transfer for the trust has to be a true sale. It can't just be an assignment. It has to be the sale. See, he says the transfers must follow the steps designated in the structure, and since each transfer must be a true sale for purposes of creating the bankruptcy remote structure, all transfers following the steps have to be followed. And so all steps must be true and complete sales between the parties in order to qualify the trust for what is called the remit qualification. That's the IRS status of pass-through. We don't have to pay IRS taxes. And I just wanted to bring to your attention an example here. I've pulled it up from my website. This is on item number, I got it right here under foreclosure defense number 4, sample docs. We just use these sample documents in the workshop. And here it is. Here's a corporation assignment of deed of trust, and they assigned from the originator, which in this case, MERS had assigned it to B of A, and then B of A is now as a servicer, which is illegal. And so now B of A is going to just flat assign it to U.S. Bank National Association as trustee for the mortgage-backed security. That's exactly what he's talking about right here. Can't be done. And assignments relate to real property instruments and have nothing to do with the negotiable or non-negotiable instruments, which of course James and Joe have talked to us extensively about, the tangible and the intangible. You can review those live streams. Fascinating, and we'll be having more of that soon. The assignments are strictly regulated by state property law. So the statute of frauds applies to assignments since these are real property instruments. You cannot assign a mortgage or deed of trust in blank. There is no such thing as a bearer assignment with respect to a mortgage or deed of trust. These are excellent reminders. Let's think about these, because this is the point. You cannot assign a note just like you cannot assign a mortgage or deed of trust in blank. And yet they do all the time. There's got to be ways that we can use this information to help everybody keep their homes. Here he talks about the holder in due course, relates to the notes, has nothing to do with the mortgage or the deed of trust. In order to assert a holder in due course status, the transfer of the note to the trust correctly via the required chain must occur before the note is in default. And the transferee must take the note without knowledge or notice of any claims or defects in the document. If the note is in default during any link in the transfer process, the holder in due course status is lost. Did you catch that? All of these assignments, the ones that I just showed you, like this one, guess who did this? Recon Trust. They did all of these after the notes were in foreclosure. This is part of the foreclosure process. So that violates the holder in due course status. Now that is key, because only the holder in due course can file foreclosure. Help me with this, guys. Let's use this. Let's structure a solution that everybody can use, because what this means is everybody that has foreclosure documents, all the holder in due course has been violated. All the statuses are gone. I've got some pretty smart people watching. Help me out. Let's come up with something that we can use for this. And then, of course, they talk about any assignment of a mortgage or deed of trust from the originator directly to the trust is per se invalid, which is exactly what we just talked about. All of these talk about exactly what they do. They do this over and over and over. In fact, when I did those 18 properties for the Attorney General in California, I believe 56% of them had assignments exactly like this. They went from somebody, MERS, B of A, some servicer, directly to the trustee of the trust. That would be invalid, and that would violate the holder in due course. The A to D invalidates negotiation of the note. Any transfer of the mortgage note from the originator directly to the trust is also likewise invalid. And this is the case because such a transfer would disregard the true sale. They're supposed to sell these of the same note from the originator to the sponsor and the subsequent true sale from the sponsor to the depositor. Any late transfer of the note from the originator to the trust would be invalid, because at that point in time the originator would have no ownership rights in the note. Exactly. These are powerful truths, and I wanted to bring them into our mind again. Let's use these in our lawsuits and in our filings and claims. Affidavits. With respect to affidavits, simply attaching documents without first laying a proper evidentiary foundation for the admission of the documents is simply hearsay. The affiant must be able to state that the attached documents are created or maintained in the regular course of the business, that the creation and maintenance are part of the and that the records were created at or about the time the transaction was recorded. And then, of course, it talks about lost or destroyed notes. And if the enforcement of lost or destroyed or stolen mortgage notes is another issue that comes up repeatedly. He discusses the UCC. A person not in possession of a mortgage note is entitled to enforce the instrument if the person seeking to enforce the instrument was in possession of the instrument before it was lost, or has directly or indirectly acquired ownership of the note from a person who was entitled to enforce it. And then after acquired property doctrine. This is an interesting concept because I believe it applies a lot. They sold it before they bought it. And that this is the doctrine that says if party A obtains title to the property only after falsely selling it to B, you sell it first, you get paid, then you go buy it. the doctrine states that B person owns it, not A, because but they did this issue, the transaction backwards. And this is what Neil Garfield has said for years. They did everything backwards. They sold the mortgage-backed securities first, got all the money, and then they said, "Oh, better go make some loans." Then they went out, created loans, and so there's a whole lot of things going on that I believe we can use for our own benefit. I've asked several people for this next week to bring us up to date on some new things that are discovered. I don't claim to be a master of all of this technical information. I'm a voice. I share what I hear and bring to you parties that can share the information more clearly. And one of the things that we're going to be talking about later this week is patents. Evidently, the banks have filed patents to create foreclosure documents. I've been asking some people to bring that to us in a more technical, analytical understanding, because there's a lot of people that understand this more clearly than I do, and I'm asking for everyone that does to participate. Let's help each other. If any of you can help draft boilerplate complaints that owners can file, that's really one of my next pushes. Okay, we're using, requesting loan modifications to help delay foreclosures and stay in our homes. We're using OCC complaints. We're trying to file, sometimes people file BK. All these efforts to try to push off foreclosure to keep the house a little longer. But we need some kind of boilerplate classic lawsuit that everyone could file, or some other kind of a solution. Help me come up with these ideas. Let's work together so that everyone can actually be assured they can keep the house. They don't necessarily just want it free and clear. They want a loan modification that they can afford. And that seems appropriate and reasonable considering all the bank fraud and all of this fraudulent foreclosure paperwork. Now, at least we know for sure that mortgage assignments can be challenged. How do we challenge those? How do we get into court? Do we do it at the state level, the federal level? Help me on this. Let's offer some guidance. So I'm going to be reaching out to several of you. I know some of you already, and there may be others that I don't know yet. If you have an expertise in this, please contact me. Help us try to draft a solution so that people in this country can keep their homes. We don't need any more devastation. Another issue that we're working on, hopefully later this week, is to bring one specific show about what a crisis the foreclosure crisis is, because it is a horrific crisis to everyone facing the loss of their home. I get emails that I can hardly bear to read. People call on the phone and talk about SWAT teams, owners. SWAT teams are going to take owners out of their home. We've seen armed military videos as they take owners out of their home, just simply because they were lied to and defaulted on their loan so that they could get a loan modification, and now they're being taken out with SWAT. So these are the scary times that we're facing, and they are scary, but we can fight back, and we must fight back. We just thank you so much for watching, and we encourage you to take every little bit of information that we bring and pull it into your understanding. Reach out to others in your neighborhood. I know that several of the activists are already telling me how they're helping their family and their friends look at their documents. That is so fabulous, because this is a true rising up of the people. We have to rise up and say no. And we have to understand what we're saying and understand what's happening to us. And the more people around us that understand, the more people in the country that understand. So we thank you so much for standing up for right and justice and reaching out to everyone you know to help them do the same. This is CJ signing off for today. We'll talk to you tomorrow.